Yes, good evening to the participants of the SLW600. Karibu sana. Welcome to my class of the blended mode, and that will be the virtual mode today. And I put it something on the screen. Can anyone could read it, what I put on the screen? Can anyone unmute and read what I put on the screen? Could you see it? Yes, I will read it. Doesn't matter because you could not be able to see it and you could not read it and you mute it only. That I will read it what I kept on the screen. Okay, no matter, huh? So I kept on the screen this thing. Welcome to the students of the SLW, the virtual class SLW600 virtual class 19-2023 from the 9:10 to 10 p.m. And today topic is the last topic, which is the problem solving, or we can say the case briefing. So without wasting the time, let me see that what our syllabus says regarding the today class is concerned. Yes, the 2.4 solving the legal problems and framing the legal arguments. That is the last point. That the tackling the legal problems and framing the legal arguments and appraise of the legal arguments. These are the things that we are going to study in the today class. So, and this is in one word, in other word, we can say it's a case briefing. It is nothing but a case briefing, which I put it over here, and I'm sure that you could see it. How to brief a case, that is called the case briefing. When you say the case briefing, it's nothing but the outline of the case, and the outline of the saying that you will give the only bird's eye view. But the case briefing, there are certain norms to be followed over there, and you will follow it, and you will make the case briefing. And this could be studied in both the way in the communication skills for lawyers and the legal methods also. But it is also included when you go to the Law School of Tanzania, and every problem and every decision should you have to make the case briefing. If the problem would be there for the Iraq model and the case briefing is there, it should be in P-FIRAC model. That what is the model and method and style that I will explain you in this class. So how to brief a case? Here the distinction says a case brief is a dissection of the judicial opinion. Is a judicial opinion. It contains a written summary of the basic component of the decision. That is called the case briefing. It contains a written summary of the basic components of the decision. And B, persuasive brief, trial and appellate are the formal documents the lawyer files to the court in support of his or her client position. Whatever the cases that you are keeping to support your argument is concerned, that is only the persuasive value. Either it may be the local cases or it may be the foreign cases. It's the persuasive value only. If the judge will be satisfied with your persuasive cases, then definitely will rely on it and give the judgment in your favor. If he doesn't agree to that one, that he will not agree, then the decision will be done in a different way. The function of the case briefing is, case briefing helps to acquire the skills of the case analysis and legal reasoning. How a case should be analyzed and what is the legal reasoning, and briefing a case helps to understand it. Because the cases should be running to 20 to 30 pages, 30 to 31 pages, even 50 to 100 pages case. That is disposed by the Court of Appeal or the High Court. So at that instance, you have to read all the cases and you have to summarize it in the P-FIRAC formula. If it is a decision, if the problem is there in the Iraq formula, but if you know if the case briefing is concerned, which includes the P-FIRAC, that includes the Iraq model also. Now let us see what is the case briefing at your memory. Brief helps to remember the cases you read for class discussion and for end of the semester review, the final examination, and for writing and analyzing the legal problems. So that is the advantage of the case briefing. And a case briefing is nothing but the comprehensive of writing the entire decision within the 3 to 4 pages by following the certain format, P-FIRAC format, P-FIRAC style, or P-FIRAC model for the case briefing is concerned. Don't try to memorize the case briefing. You need not to memorize it. But if you follow the composition, that is enough to write in the side-heading components. P stands for parties and F stands for the fact I stands for the issue, A stands for the application, and and the and the C stands for the conclusion. But a PFIRAC, that is PFIRAC. F means facts, I means issues, R means rules, A means application, and C means conclusion. So that is the model we can view. Of course, I have already sent all the models and the briefs and examples also to the Rosta and Monica in the email just before, that you can have a glance of it so that you could clear to you that what I'm teaching to you today. So briefing a case, the steps. What are the steps involved in the briefing a case? Although the exact form of your brief may and can vary from the case to case, the following part should be appear somewhere in your brief in a way that helps you to understand the case and recall the needed information. Read through the opinion first so you will understand the overall story and identify the important facts, etc., before beginning to brief the case on a proper manner. Now, anyone can unmute and read what is this heading. The participants, anyone can unmute and read that what I put it on the highlighted it, so that I could know that you are hearing me and I am hearing you, both traveling the same boat to reach to the destination.
Heading.
Go ahead.
A case name to identify the parties, court name, date of the decisions, page number where the case appears in the textbook.
See, that is not the way of reading. I will read the style. Heading, then A, case name within parentheses to identify the parties. B, court name. C, date of the decision. D, page number where the case appears in the textbook. It is the heading section. When you are writing the heading section, you have to follow this style. And the example also I have given and sent to you, and how it would be that I will show you now. The example. Here, one of the example which I have given, procedure, PFIRAC means P stand for procedure. And here, what is the heading of the title? Smith versus Baker. Am I right? And what is the court? Anyone can tell me the court name? Anyone can tell me the court name? Here.
Supreme Court.
Which I highlighted there. Can you tell me the court name there?
A Supreme Court of the House of Lords.
Pole sana. There is a AC is written. What is meant by AC?
Court.
Sir, air condition. AC means? If you know it, you tell me. If you don't know it, say pass on.
Pass on.
Mute. I will give the answer. Appeal court. So it is appeal court, and the year it should be not in the parentheses, it is in the square bracket. Always appeal court, King's Bench, All India reporters, time reporters, weekly reporters, which is having the volumes, it should be in the square bracket, not in the circular bracket or the round bracket. It should be in the square bracket. So here should be in the square bracket, and the appeal court, and 325 stands for what? Anyone? If you don't know, you say pass on. I will give the answer. What is this 325? I told you, if you know it, you tell me. If you don't know it, you say pass on. Don't waste the time. Haraka. What is this 325?
Sorry, Professor, sound is so.
Say person, just to say person. Okay, mute it. I will give the answer. This 325 is nothing but in the reporting where it is made, it's the page number. So Smith versus Baker, it always should be in the italics, then ends with the comma, then the
Sir.
citation should be there because AC is in the volumes, hence it's the square bracket in the year and AC appeal code and 325 is the page. And later on, who are the judges? Lord Herschel and the Stenare, MR and Lord Halsbury. These are the people who are the judges here. When you go to the again case briefing is concerned, how it will consisting of it, and here I will show you. Yes, it is here. So case name to identify the parties, court name, date of decision, and page number where the case appears in the textbook. But when you are writing the citation, first the name of the case, that is the title of the case, you should be in italics, and V should be small letter, and we are not supposed to write the verses, we are not supposed to write the V capital letter and S capital letter, that is the old style, the small V and that to be in italics. And later on, comma, then comes the year. If it is All England reports, it is the square bracket. If it is the King's Bench, it is a square bracket. If it is the Queen's Bench, it is a square bracket. If it is the Appeal Court, it is a square bracket. It is the Times Law Review, it should be a square bracket. It is the Weekly Law Review, it is a square bracket, which is having the volumes always follow the square bracket, not circular bracket or the round bracket or the parentheses. So this is the style of writing the heading, and next comes the statement of the facts. And what you write the statement of facts? Relevant facts, that's what you say. What you say? The relevant fact that you write it. So now, next point, of course, in the P-FIRAC, what they do, they will write the gist, the flex, the decoction, the summary, the head note of the case law within the 3 to 4 lines only in the P-FIRAC model, where the case briefing comes. So now the first line is whether it is the appeal case, whether it is the first instance case. And I'm sure that you know what is meant by first instance case and the appeal case. So this was an appeal from the Supreme Court to the House of Lords, whereby the plaintiff, the employee, sued his employer for negligence which resulted in the injury to the plaintiff. It is no doubt the House of Lords it came, but it is reported in the Appeal Court's Journal. Appeal Court's Journal is there like All England reports and King's Bench and the Queen's Bench. And these reports would be reported in a particular journals. These are all reporting journals, reporters you can say, like Tanzania Law Journal, we do have it. So now let us see that. So whether it is the first instance case or the appeal case, that is the first sentence. Next, whereby the plaintiff, the employee made his employer for the negligence which resulted in injury to the plaintiff. Then what is the crux? Why this case has appeared? That should have to come the question of law in one sentence. So it says that the plaintiff, the employee, sued the employer for the negligence which resulted injury to the plaintiff. And the next sentence is, the employer is pleaded voluntary not fit injury. What the employer did it? What the defense that he did it? What he took a defense, that would be coming in the third line. And defense of the voluntary not fit injury. But what is the happened over there? Whether he could succeed at it, whether he would not succeed at it, and what the court have adjudicated. That should come the last sentence. And but failed to plead the defense, hence the appeal was dismissed. Only 4 lines. You have to write it beneath the title of the case law with the citation and the judges decided, and below the facts of the case law. Yes, you want to ask anything? Do you want to ask anything? Just mute it. You are not asking. Unnecessarily you are causing the delay. Mute. You mute it. You are not functioning well. If you don't mute it, I can also mute. Okay. Now, after the crux of the case law, after the gist of the case law, that you have to write it in the 4 lines. The first line, whether it is a appeal case or a original jurisdiction. The second line, what is the question of law, which is demanded over there. And the third sentence, what are the defenses taken by the other party. And the fourth sentence, what is the adjudication made by a competent court, which is entertaining this case. Only 4 lines should have to appear there beneath the title and the judge's names. Now come to the fact. When you write the fact, you have to write the relevant fact. If the time factor is more important, like the contract, yes, that time factor is more important, that you have to write the relevant fact. And that's why that it say, write the relevant material fact. So the fact should be written in how many lines? Mostly 5 lines, 6 lines, 7 lines, not more than that. Okay, let me agree for the 8 lines. See here, facts I have given 1, 2, 3, 4, 5, 6 lines only. Okay, you can agree it up to the 8 lines because I am speaking about the time factor. It is a compulsory question and you have to do it in a less time unless you are precisely write what are the material factor in that particular case law, because that can be deduced from the original case law. Because in the examination I will give the original case law, the entire decision. From there you have to deduce it, extract it, what is the material factor of it. So that is the importance of the time factor is concerned. So, and here the facts which is given, because its original case law is Smith-Water. I will show you now what is the original case law here. Smith-Waters. Yeah, you get it now. Did you see the Smith versus Baker case law? This is nothing but Smith versus Baker case law, and again I am showing the same. I want to show you the original of the Smith versus Baker. Yeah, here you can say. Did you see here? Smith versus Baker, 1891 AC 325 is the original case law. See, they have given the original case law. This is the first page, this is the second page, and this is the third page, and this is the, only 3 pages are there. In the 3 pages, you have to read it and find the facts from there, which are very much relevant to it, from the original case law. Is it clear? Say yes. Anyone can unmute and say yes. Okay, I presume that it is a yes because you don't know how to mute and how to unmute to say yes. I don't think that you know how to unmute and mute and to say yes. Can anybody will say yes by unmuting? I would like to test
Yes,
you.
Professor.
Yes, I am happy. I am happy. Now mute it. Now mute it. At least you know how to mute and how to unmute. I don't know. Why did you join with my meeting number? You have to join with your name like the other people did it. And somebody did join with my meeting number, Professor Dr. Mohammed. And the Rutambuka joined with the name, and Rostam Mofuga joined with the name. Other people joined with the pseudonyms. You join in my login with your name, not my meeting number, not with my name. Anyway, that next time that you can correct it. So now let us go to the further. What I want to say is, yes, case briefing this is called. So here that I have shown you that, yeah, Christina, yes, it is. So let us come to the point fact. Only the material fact of the Smith versus Baker should be written over there. I wrote in the 6 lines taken from the original case law. Then issues. I framed the issues for. See how I frame the issues. I say ISSUE. Issue is the capital letters. I is the capital letter, other letter is small letter, because the side heading, and it should be bold, no underline, no punctuation. Then how I write the issues? Small Roman 1 and arrester. Small Roman number is called arrester. This is called arrester. Means the right hand side of the curve bracket is called arrester. So whether there was a negligence for not taking the measures of safeguard to the plaintiff, then semicolon. Number 2, whether the plaintiff has given the free consent to undergo the harm or oblique or virgule injury by the containing the situation which was dangerous or harmful in a matter, semicolon. And 3rd ends with the semicolon. And the 4th ends with the semicolon, because it's the last but one. Hence we should write and, A-N-D, and. And the 4th, whether the plaintiff could be entitled for the damages. Now I can ask you, you need not to write whether. No. You can write, there was a negligence for the not taking the measures for the safeguarding the plaintiff. Or we can write on the second, that the plaintiff has given the free consent to undergo the harm or virgule injury by the continuing the situation which was dangerous or harmful in nature. You need not to write whether every time. Either you can write it or you can eliminate it. Because every time you're writing the whether, it's not looks good. You can change the style. Like I change the style now. Here, I don't write whether here. See, I'm writing that. See, I changed the style. And again, is there, was there. I wrote again here, instead of writing that, I remove that, was there. Was there a proximate cause? I don't want to write it. Because every time writing the whether is not good. It's not a Sharbaro style. It is a Kijijimtu style. So I changed it. Was the whether the proximate cause between the negligence of the act of the defendant and the injury sustained by the plaintiff, semicolon. Then I can use again whether, because I change it. Whether the injury sustained by the plaintiff was the forcible, and again I remove it. Of course, here it is gone. Yeah, the plaintiff. I write only the plaintiff, but I can make it T is the capital letter. The plaintiff could be entitled for the damages. The grammatical mistake is there, not entitled, be entitled to damages. Grammatical mistake it is. Of course, in the lawyer writing, they don't consider that a grammatical mistake. If they consider it, there are a lot of mistakes would be there in the grammar. Of course, we don't consider the grammatical mistake. We see only the register. So this is the style of the small Roman. You have to use, and 4 issues are there. Now there comes the rule. So when you say the case briefing, and it also say the same thing, which is, yes, I'm coming to the case briefing. This is not the case briefing. Here I have to open it again because it is not accepting the 2 files at a time. Yes, now I am opening that file. Yes, here statements of facts are over and procedural history is over, and the proposed dispositional case of the lower court, damages awarded if irrelevant, and who appealed the why. Of course, this procedural history should have to come on the above. And now issues, substantial issues. See, I put you 1, 2, 3. Okay, you can put it there. And If there is substantial issue, if there is a procedural issues also there, you can keep it out. Then, of course, they say judgment, but judgment will not come now. The rule of law and legal principles applied. What are the legal principle applied that should come first? And if you happen to see here, this is the original case law. And P-FIRAC model, and this is the P-FIRAC model. No, this is also original case law. I will show you the P-FIRAC model. See, I kept it here only. Yeah, Krishna edited. Yeah, it is here. So, application. Either you can say argument or we can say application. But preferably, P-FIRAC model A stands for application. Here the application, first issue and what are the supporting cases or maxims or section would be there. That will be analyzed in the application. As to the first issue, see, I told you whether the defendant was negligent and separate case law. If any separate case law is there, you have to mention there. And here I have made the separate case law. See, this is the separate case law. One of it. And next is here, there is the exact case law, but here again, the other cases also comes in that. See how here I highlighted Lynch versus Nodin. It is another separate case law. And here the case law, what it says, the dangerous thing could not be escaped liability with the pleading the wrong has been done by the mischievous children. The Watoto, Watundu, na Kiswahili, that is say, Watoto, Watundu. So in case the negligent act of the defendant was for not taking the safe measure to the plaintiff was the proximate cause of the injury and the defendant could not be exonerated, means from the liability, means free from the liability. Exonerated is the legal terminology. So with regard to the fourth issue, so each issue is discussed here. First issue, second issue, third issue, and fourth issue with the relevant cases, supporting cases, maxims, sections, and noted author statements, or they can take it from any books or encyclopedia or the dictionary, we can use it. Whatever the rules that you are using, that should be reflected in the rules. That is a very important factor. And here, citation always given in the footnote. And sir, in the examination, can I give the footnote? In the examination, you need not to write the citation. Either you can want to write the citation, you can write it in the body of the answer script only, not the footnote. Is it clear? Anyone can unmute, say yes.
Yes.
Yes,
Professor.
yes, Professor.
I appreciate. So, each issue, see, here I shown the, how many issues are there? 5 issues are there. How many rules are there? All the rules are cases, not the maxims, not the sections, not any black dictionary, not the encyclopedia. Suppose if it is used the encyclopedia, either Britannicana or Americana or Black's Law Dictionary or Webster Law Dictionary, any one of the used over there, that should be applicable in the rule. And the application, take the first issue and what is the supporting document or the case law should be needed over there. That will be analyzed in the first paragraph. If it is needs, you will not to make the second paragraph. But generally, because the time factor is concerned, first issue only one paragraph, second issue only one paragraph in the application by supporting with the authorities. And 5 issues, 5 paragraphs with the supporting authorities for the each issue, that should be come under the application. Then if there are 5 issues are there, then 5 paragraphs of the conclusion should be appear. How many paragraphs? If the 5 issues are there, anyone can unmute and give me the answer. If the 5 issues are there, how many paragraphs in the conclusion should come?
5 paragraph, Professor.
Yes?
5 paragraph, Professor.
5 should come. In the same way, in the application also 5 paragraphs you can make it out. Don't make it the 2 paragraph for one issue, because time factor. See, always in the examination, time factor is more important. Please precise it and use the issue, supporting documents and supporting case laws, supporting sections, supporting maxims, supporting dictionaries, supporting anything that will be reflected in the rules. So 5 issues here. I made the 1, 2, 3, 4, 5, not more than 5. Regarding the court concluded that the defendant was negligent for not taking the reasonable measures to safeguard the plaintiff, and the plaintiff brought the notice to the defendant that there must be a risk of the injury in his working place. That is the first issue. And the second issue is concerned, and here you need not to write the first issue conclusion, second issue conclusion, third issue conclusion, fourth issue conclusion, fifth issue conclusion, but you have to write in the application, as far the first issue is concerned, as the second issue is dealt, and the throw light on the third issue, discuss on the fourth issue, and make a discussion on the fifth issue, that should be clearly mentioned in the application. But in the conclusion, need not to make first issue conclusion, second issue conclusion, third issue conclusion, fourth issue conclusion, fifth issue conclusion. Not merely writing the paragraph of each one is enough. First one is first, second one is second paragraph, third one is third paragraph, fourth one is fourth paragraph, fifth one is fifth paragraph. Is it clear? Anyone can say yes by unmute it. Say yes if you followed, if you are agree.
Professor.
Appreciate. So second issue here was gave the second paragraph. It was concluded that the plaintiff was not in a position to make the free choice as to whether the should continue the working in the situation with the risk of the injury to the himself, and then he did not voluntarily to undergo the risk of injury. This is exactly what I framed in the issues. That decision after the application.
Yes, Professor.
Giving the conclusion. Yes. Do you want to ask anything?
Yes.
Please ask. Ask. I said ask. Or mute it. You are not going to ask it. So first application, what is the outcome is there, it should be reflected in the conclusion. And second issue, whatever the application would be there, it should be reflected in the second paragraph. Third issue, whatever the application should be there, which you followed in the application, that should be reflected in the conclusion. Third and the fourth and fifth accordingly. So the fifth is, here I have given, the court found that due to the
No.
reason. Do you want to ask anything? Please ask me. Otherwise, don't disturb me. Don't speak in the middle. If you want to ask me, okay, I will give the time. Let me finish it. You ask me in your doubt. So the fifth issue is, the court found that due to the reason that the plaintiff complained about the risk of the injury which may occur, that the defendant did nothing to rectify the change and the working environment, and hence the plaintiff could be compensated as he did not volunteer to take the risk of journey of the injury to the himself. Hence the merely assumption of the risk not amount to the free consent. So plaintiff was entitled to get the compensation or damages from the defendant. That is the conclusion for the fifth issue. Yes, now you can ask me what you want to ask. If you have any doubt, you can ask me. Unmute and speak loudly. Keep your gadget near to your mouth, and your frequency should be high. The signal should be high. Otherwise, I will get the breaking voice. I saw 576162346. I did not see his microphone. Diana Daniel, I could not see his microphone. Pantilo Rotamba, yes, I saw the microphone, it is a mute. Rosta Mafuga, I did not see his microphone, whether he is present or not. If any person is present, I should see the microphone there. That means you did not have the computer savvy, the smartphone savvy, online savvy, and you are not expert in the electronic gadgets because I could not see your microphones there. Rosta Mafuge, can you speak and ask any questions to me now? Five 2346. You joined with my number. That is my. Can you speak with me now? Because I did not see your microphone. What could you speak? Of course, other people join with again my name and my number. Never join with that one. You log in with your own name. Because when you log in, they will ask you in the beginning, your own name. You have to enter it. Then your name will appear to me in the participant list. So this is a very important factor to write the P-FIRAC model of case briefing. A case briefing can be undertaken by the outlining of the case, by the P-FIRAC model, the procedure, facts, issues, rules, applications and conclusions. When the problem question is given is the IRAC model, because they will give the problem and you have to make the problem solving by the IRAC formula, IRAC style. I stand for issue, R stand for rules, A stands for application, and C stand for conclusion. And conclusion is nothing but what is held by the court in the respective issues. And you have to analyze it in such a manner. And that is a very important factor when you are writing the case briefing. So again, let us come to the point. See, somebody is speaking. If you want to ask anything, you can ask. Diana Daniel, do you want to ask anything? I could see your microphone is open. Now
No,
your microphone
Professor.
is disappeared. Again, it is open. That means you don't know how to mute and how to unmute. When you want to speak, yeah, now you muted. When you want to speak, you can unmute and speak. If you want to ask any question. If you don't want to ask any question, always keep it in the mute. That is the procedure. Rosta Polesana, I did not see your microphone. I would like to hear your voice. Can you speak me, Mosta? Polesana. So here the judgment, holding, rule of law and principle applied, reasoning and conquering, dissenting opinion, and ratio decidendi, additional comments or personal impressions, you can write it. Suppose you are not agreeing. If you are not agree with the decision of the particular court, decision, yes, my opinion, you can keep it the last side heading and you can write your own opinion. If you disagree with the decision, not necessarily that a decision will be favorable, because the school of thought will be different. That is the reasoning that we could find the descending judgment and ascending judgments. Am I right? And we have studied the ratio decidendi also. And which is justifiable, rational, can be used as a precedent for a longer period. Yes, at that instance we can say that this is a ratio decidendi. It can be used as if any case comes under the similar facts are concerned, the decision would be applicable. That is called a res judicata. Participant, do you want to ask any question? Because now the time is 9:56. Still we do have in our hand 4 minutes. At any time, of course, it will make the indication to me that when it is going to be closed. And I have given the 2 candidates work to whom I taught in Sekuko. Sebastian Kolava University College at the time is the Lushoto. One is Christina, another is Kazia. And the two words, original case law and the PIFIRAC model. And I sent to you for the Rosta and Monica emails as a model to know if a case law is given over there in the examination, the total case law, then how do you make the case briefing? And you have to follow the PIFIRAC model. If you know the PIFIRAC model, then the problem question is very easy to you to solve it, because problem question is IRAC, Iraq model, and the case briefing is PIFIRAC model, PFIRAC. So that is the thing which is made. So I have given the entire handouts of today sent to you in advance so that you could have to read them and you can hear my YouTube virtual class, and that will be the adding a feather to your cap, and I'm sure that you could understand it, what I said and what I did it practically. You could understand it. Is it clear? Anyone can unmute and say. Or you can ask me a question. But keep the gadget near to your mouth and speak in a sonorous voice, not in a paka voice, murmuring.
Sorry, Prof.
Yes,
Can
please
you
ask me.
repeat the
No, your voice is
Can
breaking.
you repeat the Can you repeat the P-FLAC?
See, you can rehear, you can rewind it, you can watch it, you can hear it as many times as you can, so that you could understand what I said and what I have given to you, the model. The model which I have given to you, and that today I have given the explanation, and you synchronize it. If you did not understand it, you repeat it. Again you repeat it. Again you repeat it, so that you could understand what I said and what I have given the handout to you. So that will make you to understand the thing. That is the reason I make every of my class would be recorded, because those who are absentees, at least they can get the chance to hear it and they can read it and hear my YouTube so that they could understand it. So I shared my file, then I explained to you the model, I have explained to you the other way, and what I given the model is the correct model. The other things you could find it in the theoretical, then you can eliminate it. You can delete it. You can forget it. My model is the right. If the additional things are there, just you can omit it, delete it. Because theoretically, the more things they have given which are not essential are necessary to us. You are trying to speak it, but your voice I am not reaching to you. Number one. Number two, your frequency is not that much powerful to I could understand you. And hence, just you mute it. Even though you are speaking, it is not audible to me. But my voice is audible to you because I know the signals are strong, number one. Number two, I could know whether what I am speaking, whether you are hearing or not, I can see on my screen. When the microphone of mine, which is in the green color and palpitating, that give the sense to me that you are hearing me. Now I stopped talking, then automatically microphone did not appear. When I start talking, then microphone appeared. So it gives the sense to me that you are hearing me. And this is not the first time I am teaching. I am teaching like these classes more than 3 years. Tell me, how many years? Tell me how many years?
3 years.
Tell me how many years I am teaching the online classes. Just now I told
3
you.
years.
Repeat.
4 years.
Run. I did not say 4 years. I did not say 4 years.
3 years.
I said 3 years. From the inception,
3 years.
April 2020. April 2020. From that onwards that I am teaching in the online and the same link and same Cisco WebEx, I am using it, which is a Bure for the 50 minutes. Earlier, it is a Bure for the unlimited time. But because of the pandemic, and he kept it 2 hours. Later on, he decreased to the 1 hour. Now it is decreased to the 50 minutes, or sometimes he may forget it. It may extend to 1 hour also. But general timing is 45 to 50 minutes they are giving it. Bure. If I pay the amount, they will extend to me even for the longer time also. But I am spending a lot of amount for my mobile data because every 3 days, every 4 days, I load 10,000 rupees. That is Tanjana shillings. Every 3 days, every 4 days. Because I teach them, I share my file, and I record them, I can upload them, then I will send to you. That is my intention of it. And my slogan that you also seen. What is my slogan? At any time it will stop. What is my slogan? Sir, we don't know. In each and every class, my slogan appears. And you say, I don't know. Anyone can say my slogan? Unmute and say. At least say, I don't know. I will give the answer.
Pastor.
In all arms, education arm is at zenith. I repeat. In all arms, education arm is at the zenith. And that is my slogan. And you don't know till today what is my slogan. Because I already shared my slogan in each and every class which I recorded it. And in several times that you saw it, but still we can say that we don't know. And here I am showing you again the slogan copy to you so that you could understand what is my slogan. And here, this is my slogan. Yeah, just a minute. Did you see it now? I highlighted. Read now. Read now. What is my slogan? Read now.
In all arms, education arms is a zenith.
Kiswahili. Kiswahili.
Katika sadaka zote elimu sadaka iko kwenye kilele.
The other person's voice is breaking. See, this is my slogan.
Katika sadaka zote elimu.
Yeah, Rutambuka, your voice is breaking. You have to load at least 1,000, 2,000 as a data, otherwise breaking voice. In language, the Telugu language up is there. Anni danamulakana vidyadhanam minna. Katika sadaka, zote ilimu sadaka iko kwenye kilele. That is my slogan. And other thing is, service to man is service to God. Utumishi kwa Mwanadamu ni utumishi kwa Mungu. That is my slogan. A service to man is service to God. In all arms, education arm is at zenith.
Tanzania, dumisha uhuru.